Good morning. Really quickly, I just want to respond to a question that Seb left for me. Seb, criminal negligence is a mens rea standard. That means that's the mental state required in order to convict someone of that particular crime. So when the Texas Penal Code for the interference with the duties of a public official, for that particular statute, the required mens rea is criminal negligence. And it's called criminal negligence for a couple reasons, mostly to differentiate it from regular negligence, which is a tort standard. It's not a criminal law standard, it's a tort standard. Criminal negligence, however, is the criminal standard basically of negligence, just a little more culpability than your standard tort negligence. If you go to Texas Penal Code Chapter 6, you could read all about these various mens rea requirements. There's 4 different ones. They're based on the Model Penal Code. The Model Penal Code, I think, is a little clearer because they instead of calling the most stringent requirement intentional, they call the most stringent requirement purposeful. You have to purposefully do something. And that shows that not only do you have to intend to do the act, but you also have to be intending for the outcome. You have to be intending to do an act that would result in that particular outcome, as opposed to just intending to do an act. Like if I point a gun up in the air and I pull the trigger, I'm intending to fire that gun, but maybe that bullet lands a mile away, crashing through someone's skull and killing them. I'm not intending for the result. Whereas if I point the gun at somebody at their head and I pull the trigger and it hits them in the head, well, then I purposefully shot it. So that's kind of the difference between recklessness as a standard and purposefulness or intentionalness in the Texas Penal Code. And the thing about mens rea requirements is that they're kind of hierarchical. The lowest level of requirement is criminal negligence. And if you satisfy any of the 4 different levels of mens rea, you will satisfy criminal negligence. So if you prove recklessness, you've satisfied criminal negligence. If you've proven knowingly, you've satisfied criminal negligence. If you prove intentional or purposeful, you've satisfied criminal negligence. And so on up the ladder. If the mens rea requirement is knowingly, then whether or not the statute says it doesn't matter. If you prove intentionally or purposefully, then you've satisfied knowingly. If the requirement is recklessly, then you can prove recklessness, or you could prove knowingly, or you could prove intentionally/purposefully. So that's just a mens rea requirement. It's just talking about the state of mind that Boren had to be in. And so what that is saying is that Boren had to, or that a reasonable person in Boren's position would know that his actions were likely to result in the obstruction of that officer, impairing the officer's ability to perform his duties, distracting the officer, delaying the officer, whatever the words in the statute are. I don't remember them. I don't have them in front of me at this time. But would a reasonable person have known that? And probably a reasonable person would. If you're looking at what auditors do, auditors generally aren't reasonable people. They're generally people who are disaffected with society, who don't understand how society generally functions, and who have criminal records, and they blame society for their criminal records. It's the cops' fault that these laws exist. Well, the cops didn't pass them; they just enforce them. Oh, but it's still the cops' fault, right? I mean, it's that level of mentality. So, would a reasonable person have thought that there was a genuine risk that acting the way Boren was acting would delay the officers? And I think a court would find that there were. Now, I understand that all the auditor supporters don't think that it would, and I am somewhat empathetic with their arguments. I think officers today generally are giant pussies, but that's neither here nor there. The officers do have the right to control the scene, and It would be, if you're gonna claim that the First Amendment grants you the right to film there and to act in those ways, I would suggest to you that you might look back at, say, Turner v. Driver, where the court specifically states that your right to film in public is subject to reasonable time, place, and manner restrictions. Now, again, the court's view of what is reasonable, especially after the officers say, well, I don't care if they film, I just want them both kind of in the same general location so I can keep an eye on both of them at the same time instead of having to look to my right and then to my left and then to my right, because it's too distracting and I can't focus on the guy I have out of the vehicle who I'm questioning, right? So I am not saying, by the way, just so everybody is clear, nor did I say in the last video that Boren's going to be convicted of it. I think there's, especially with this current epidemic going around, there's a very real chance that they won't prosecute him on him because they don't want to put him in jail and, you know, risk. I mean, it's a pretty pissant crime. So I don't know that the DA is going to prosecute. So they might just dismiss the charges and what have you. So, I mean, I think there's a good chance it won't actually get into court. And once it gets into court, well, you know, then people get to make factual arguments. And I don't know the relative credibility of Boren, and I don't know the relative credibility of the cops, but I think there is a reasonably good chance that Boren could be convicted of it, if that helps. Now, I'm not saying he will be. I'm just saying there's a reasonably good chance that he will be convicted. I mean, if I was him, I would be concerned about actually going into trial on it, because I would be concerned that I might lose. And, you know, there you go. Anyway, so thanks for watching. Have a great day.